before we get into like the details of what's been going on in the case, what's been requested, what the court has ordered, what the contestations have been, be I think it is important to say um, the significance in many ways of this case, because as many of you probably know, this isn't going to be resolved anytime soon in terms of the overall final judgment, right? It's going to be running for probably several years to come, and the immediate kind of urgency of the situation obviously demands that action is taken by the court, by the political organs of the UN, and so on, if the harm that South Africa are um, alleging in the case is to be stopped, right? And so the um, in some ways, the significance of the case itself, to a large extent, we've already seen it with the performance of the case, the kind of spectacle of South Africa and the South African legal team that you see in the picture there, presenting, particularly in the January hearings and again last week, and the impact that had on people around the world watching, the realization for many people who hadn't maybe followed things too closely in Gaza to realize the extent of the genocidal intent, the extent of the genocidal um, acts that have been perpetrated by the Israeli state and Israeli military forces over the last now coming on 8 months. So for a lot of for a lot of people, like in many ways, the arguments that were put before the court in January and since then have this gravitas and this weight that, for all of the importance of the media reporting, the reporting by human rights organizations, or the reporting by Palestinians on the ground, and many of the kind of citizen journalists reporting we've seen from Gaza, there is, for better or for worse, obviously this authority and this gravitas that the International Court of Justice, as the highest court in the UN system, has. And so for a lot of people and institutions, including, and we get to the Irish state position and the Irish government and what they can or might do in relation to this case, because Deirdre did ask me to speak to that as well, and I know there may be questions on that, but we can't deny the reality that a lot of people were very skeptical about this claim that Israel could ever perpetrate genocidal violence. The warning signs were there from the very start after October 7th, and we had, from within the first week, genocide studies and Holocaust studies scholars, many international lawyers, a few days into it, looking at what was happening, looking at the statements that were being made, and raising the alarm already about the possibility of an unfolding genocide at that point in mid-October. And that was then backed up by some of the statements that were made by UN special rapporteurs and others. But there was a lot of skepticism about that, a lot of unwillingness really to accept or even countenance the possibility that Israel could be perpetrating acts of genocide. And so the fact that the International Court of Justice has taken that as a serious possibility and is dealing with this case, on that basis, that has caused a lot of politicians, political figures, and institutions, since late January, since the first provisional measures ordered by the court, to take this more seriously. And we've seen the knock-on effect then with decisions that have been made around reviewing arms export licenses, decisions in universities, in other public institutions about reviewing relations with Israel. And there's been a lot of reference to the International Court of Justice proceedings and provisional orders, right? So there, that whatever happens in the final judgment of the case, what we have so far are only provisional measures, but they have had an impact. And a lot of the noise and contestations and discourse around the court has shown how far-reaching the impact and implications of this case could be or will be. And so just to kind of set the context a little bit, I have a couple of these images here, which you can see that show from different angles or different perspectives what people thought were thinking about the case before, after South Africa had filed the application, but before any hearings had been heard or any even in provisional measures had been ordered. So this was an image that was circulating on some of the pro-Israeli social media channels before the first hearings in January, and we see the image there of the Palestinian militant figure and the judges of the court being represented as sheep or as puppets in his hands, right? And so this is, we've seen this time and again with the International Criminal Court as well. Anytime there has been a move forward by the International Criminal Court, whether that was like originally accepting that Palestine could be a state that could join the International Criminal Court back in 2015, or when the investigation formally was opened in 2021, or most recently there a few days ago with the arrest warrants, this idea that the International Criminal Court or the International Court of Justice in this case is an anti-Israel institution, is biased, is anti-Semitic, and so on. There was a lot of this language from the Israeli state and its officials talking about South Africa's case as a form of blood libel, talking about the South African legal team as the legal arm of Hamas, and so on, right? So we see from one side Israel already trying to delegitimize the proceedings before they've even started. There was a question mark back in January, some of you may remember, as to whether Israel would even turn up for the case and the hearings, because with many other UN bodies and international institutions, Israel has this approach of not engaging, of saying that they're not legitimate institutions because of this bias that they're alleging, and they will refuse to engage, or they'll refuse to allow UN fact-finding missions access into Israel and the Palestinian territories and so on, right? But because of the particular gravitas and authority that the International Court of Justice has, they did ultimately decide it was important to turn up and to defend the case. But they have, since the initial orders came out in the most recent round of hearings there, some of you may have seen last week, the legal team and the representatives that were there for Israel did a much smaller representation and seemed to be trying to send a message that they weren't engaging or taking this as seriously anymore. They did also make a lot of noise complaining that they weren't given enough notice, that South Africa are abusing the process by continuing to go back to the court for extra requests, and that they're not being given enough time to respond, and so on. And so, but like, as people have pointed out, when a big part of the starting point of this case and the arguments that South Africa are making start with the first evacuation order, when Israel in around the 10th or 11th of October gave the more than 1 million people living in the northern part of the Gaza Strip, gave them less than 24 hours notice to pack up their lives and flee and evacuate out of their towns and cities and home areas, and to go to the southern part of the Gaza Strip. And so they were given less than 24 hours to do that, and the Israeli legal team are complaining that they're only given a week's notice to respond to a 10-page legal submission at the international court, right? And so they are trying to undermine the process at various stages along the way, but still for now at least engaging with it, right? So we have those attempts from the Israeli side to delegitimize it. We had this response. This was an image that was circulating on Palestinian and Arab social media after the first provisional measures order in January, where for all that the court did order and did find against Israel, one of the key requests that South Africa had for the order of full and complete cessation of military hostilities and operations by the Israeli forces in Gaza. That was the main thing that South Africa had asked for, that wasn't granted by the court. And so there was a lot of disappointment, understandably, from the Palestinian side, and this kind of image there representing the kind of broken system or justice being broken there. And so there was disappointment there. There was the on a third view of it from the Irish Times. Cartoonist Harry Burton there just showing the ICJ as a small kind of opening or a small crack of light amidst the rubble in Gaza. And I think that's maybe a useful metaphor as well, that there is uh, a reality that one institution like the International Court of Justice will inevitably have difficulties resolving a situation as catastrophic and as devastating as we've seen, with the extent, the scale, and the severity of the Israeli onslaught on Gaza for the last 8 months. And we have this, fundamental um, problem with international law being, ultimately a voluntary system, ultimately relying on states who participated in it being good faith actors and being willing to accept the determinations or the findings of international bodies. And a lot of the Palestinian perspective, I think, that would be critical of the amount of stock that's been put in institutions like the ICC or the ICJ would be based on the the intuition and the understanding that Israel is not a good faith actor, is not going to engage with the judicial bodies in a meaningful way if there are findings made against it. And unfortunately, that's obviously what we have seen, is that there have been a number of orders now made by the court which Israel hasn't complied with, and very clearly is ignoring. And so that's why South Africa has felt compelled to keep going back asking for more, right? And so there is the longer term question of, ultimately in the final stage, will the court find that what Israel has been doing for the last 8 months and counting in Gaza is a breach of the Genocide Convention, is a form of state implementation of genocide against the Palestinian people, right? That will be some way down the line. But I think what South Africa has understood, and part of the reason that it's taken this case in the International Court of Justice, is because there is this mechanism for these emergency injunction kind of orders that are called provisional measures, that can, that can be used as part of a broader kind of political response to the situation as it's unfolding. That part of the value of the ICJ having this option there is that it does allow for more immediate intervention without having to wait for the final determination, right? People, some of the Western states particularly, have been critical of South Africa, saying that they're kind of abusing this technical possibility that's there, and it's kind of a form of lawfare, and a way they've used the fact that the International Court of Justice has jurisdiction over genocide, because it doesn't in the same way have automatic jurisdiction over war crimes or other breaches of international law that may be less contentious in Gaza, and they're using the jurisdiction that the ICJ has over the Genocide Convention as a kind of a backdoor way to get a judicial intervention in a case that's from the Western perspective is not really about genocide, but is about international humanitarian law and violations of the laws of war. South Africa, in its some of its own articulations, and if you listen to what the some of its officials have been saying, are not shying away from the fact that this is a tactical and in some ways political intervention, but they do absolutely and definitively believe that there is a valid case and argument that the Genocide Convention has been definitively and systematically violated by Israel. And I think the strength of their written submissions and their oral pleadings do back that up, and they are this is a serious case that they have mounted. And the fact that the judges have engaged with it to the extent that they have, the fact that the two orders that we have so far, and possibly a third one coming very soon, do speak to the significant kind of legal consequences of Israel's actions under the Genocide Convention, and so this kind of idea, this narrative that Israel, because of the nature of its own historical origins, and the founding of the Israeli state in the aftermath of the Holocaust, that Israel could never itself be accused of, never mind responsible for perpetrating genocide. I think that narrative has been debunked, and so there will be a case decided here on the merits and on the substance of it. And so so that's kind of around the significance of the case itself. I've just got a little bit of a roadmap there for the slides, which I'll run through some. I probably won't get through all of it, but just on that first point on the significance of the case, I mean, so one of the things that has been pointed out, was the fact that this was, any state that's party to the Genocide Convention could have brought this case, but it's not an accident, and it's not a surprise in many ways that it was South Africa that was the one to do so, partly because of its own history of solidarity with Palestinians, and its own kind of common anti-apartheid struggles, and the way that through the UN system and through the 70s and 80s, repeatedly the South African anti-apartheid struggle and the Palestinian liberation struggle were joined together and referred to in parallel as part of the third world agitation in the UN system at that time. And South Africa has its own history of litigation at the International Court of Justice when the apartheid regime was in place in South Africa and was occupying Namibia and imposing the apartheid system there. There was a series of cases through the 50s and 60s, including cases brought by Ethiopia and Liberia on behalf of the African Union in the 1960s and the broader kind of African peoples to try and bring a legal argument against the extension of apartheid in South Africa and Namibia. Ultimately, that was unsuccessful, and that's, I suppose, there was a particular kind of politics of the International Court of Justice and the judges at that time, but South Africa obviously does have this strong appreciation for the solidarity movements around the world and what they did through political, diplomatic, economic, and also legal and judicial interventions in support of liberation and equality in South Africa. And so you have, that context there, and a lot of Palestinians, I think, felt very strongly that South Africa, in the way it presented the case, was not just speaking for Palestine, but also speaking with Palestinians, referring to the language, the categories, the reference to the ongoing Nakba, the reference to the Palestinian refugees and the right to return, giving voice to the Palestinian perspective in the International Court. And that was something very significant, whatever happens with the case itself. And there is also, this idea that what has been there for a long time, this kind of taboo around accusing the Israeli state of genocide, or of even of apartheid or settler colonial elimination, that that the gatekeeping around that has been shattered to a certain extent as well, and that there is this evolving kind of battle now between the global South and its kind of increasing kind of capacity and willingness to agitate in the UN and the international legal system against what's left of the relics of colonialism and imperialism in the international system. And so that this is beyond just the technicalities and the legal arguments in the case. There is this political context which is important, I think. One other kind of interesting just side note to mention, and it goes to that point about the whether the court would in January or since then make that full order, essentially to order Israel to suspend all military operations. This was something that Bosnia had also asked the International Court of Justice order against the Serb forces in 1993 when it was bringing its case against Serbia at that time, and at that time the International Court didn't make that kind of full order of a ceasefire, cessation of military operations, and so the Bosnian genocide survivors wrote this open letter to the judges before the January decision was made, saying that we know all too well what it means to have had an International Court of Justice case going on, for that order not to be made, and then what the consequences were after that. And they spoke about the genocide in Srebrenica in '95 coming after the International Court of Justice failed to order a ceasefire in '93, and they're saying this is your chance now to remedy that historical mistake, essentially. And the South African legal team have subsequently kind of made reference to that precedent in their own submissions as well. It wasn't enough to sway the judges in January or in March in the orders that they've made so far, although, as we can talk about, they did come closer to doing so in March. But that's just to mention that. I can kind of come back to this. I've kind of touched on some of it already. The International Court has its own kind of colonial baggage and history, like all of international law does. And so we have to kind of, I suppose, be mindful of the limitations of it, and not invest too much faith in an institution that has historically been quite conservative, even if the makeup of it and the geographical representation is much more balanced and democratic now than it was, say, in the 1950s or 60s, when it was dealing with the cases against apartheid South Africa, when it was very much more obviously a Eurocentric or Western-centric institution. But that there is still an innate kind of conservatism among judges in general and international law judges in this context, and so we have to be mindful of that. But I think the fact that the job that South Africa have done on pushing them on making the arguments time and time again, of giving the judges as much of a possible basis to expand their view of the situation in Gaza, the South African legal team do have to be really commended for that. But it is an uphill battle, and ultimately, when it comes to it in the final question of the merits decision down the line as to whether the Israeli state is responsible for perpetrating genocide, there is, and people will probably be familiar with this, there is a a big obstacle there in terms of how genocide and how narrowly genocide is defined in international law, and how how high the kind of evidentiary threshold is for particularly for proving genocidal intent on the part of the perpetrators, when we're talking about individual perpetrators, and particularly on the part of a state when we're talking about state responsibility, as we are with the International Court of Justice. And so even in the case of there's only been a relatively small number of genocide cases in the International Court of Justice. Two of them were against Serbia, brought by Bosnia and Croatia back in the 1990s and early 2000s. And those cases, like the Bosnia case I mentioned, was submitted by Bosnia in 1993 while the war was still going on. We only got the final judgment on the merits of that case in 2007, and so that was a 14-year process before we had a final decision on the merits. And in that final decision, the International Court of Justice said that there wasn't enough clear evidence in general to find the Serb state responsible for genocide across the board in its execution of the war in Bosnia. And it was only the very specific instance of the Srebrenica massacre that has been considered as an act of genocide by the international courts, that which goes to the International Criminal Tribunal for the former Yugoslavia as well. And so there is this historical precedent that does suggest that it is a very high burden. That it's obviously, the law is fluid and can evolve, and that doesn't just because something was decided in one case doesn't necessarily mean it will follow in this case. What the court said about the definition of genocide and genocidal intent there was that if there's no kind of specific written plan of extermination in the way that there was during the Holocaust, say, or no, no equivalent of a final solution type policy that's explicit. If that's not there, then to determine that the acts of violence were being perpetrated were indicative of genocidal intent, that has to be the only reasonable inference that can be taken from the actions, right? And so what they said in for the most part in Bosnia, the Serb forces were engaged in acts of atrocious violence and many acts of war crimes and persecution and ethnic cleansing, but that because there were other possible explanations for the Serb violence, which could be in some cases the displacement of the population rather than its elimination, or which could be the winning of a war, even if the methods to win that war were going way beyond what's allowed or permissible under the laws of war. If the intent was to destroy the Bosnian resistance, for example, rather than to eliminate the entire or to eliminate the Bosnian population in whole or in part, then if there were multiple possible or explanations for the acts that were perpetrated, and genocide was only one, but not the only one, then it couldn't be held to be a definitive case of genocide. And so we have other cases going on at the moment that were submitted before the South Africa-Israel case, one against Myanmar that was filed by the Gambia on behalf of the Rohingya people and alleging genocide against the Rohingya, and another case which is somewhat different in the in the way it's being argued, but is the Ukraine versus Russia case. And so those what happens in those cases could also determine how the court sees things in the South Africa Israel case. But one argument that will be made is that there is the evidence of the genocidal intent, the statements that have been made by Israeli leaders essentially are an explicit, do speak to an explicit genocidal intent, that there is, by putting together the statements that are being made by Israeli leaders with the actions of the Israeli soldiers on the ground, and a lot of the social media posts, videos, and so on are being shared by Israeli soldiers that are referring to the statements of their leaders, that if we join the dots, that there is that only reasonable inference there, or there is that explicit genocidal intent there. But that will be a question ultimately that the court will spend a lot of time on once it has the full submissions in the case and once it's debating on the merits. But what it's doing in the initial phase that we've been in for the last few months is just answering the question of whether it's plausible that the rights that the Palestinians have under the Genocide Convention to be protected from genocide, whether it's plausible that those rights have been violated, and if so, the court can then order provisional measures as an urgent way to protect those rights. And so that's what we've had. I've got a little bit of a timeline there. I'm happy to share these slides after, because I probably won't get to go through everything, but we had the case filed in December. We had the initial hearings in January. We had the first provisional measures order in late January, which I'll speak to in a moment. We then had a second request for further provisional measures in February because of the impending invasion of Rafah. At that point, that South Africa went back to the court. Israel responded, and the court at that point said, the situation is perilous in Rafah, and Israel should comply with the January provisional measures order. It kind of implied, it didn't say explicitly, but it implied that Israel up to that point hadn't taken steps that it should have been taken to comply with the January order, but it didn't order any new provisional measures as South Africa had requested. Then we get into March. Let me just forward on to the next slide. And just someone please do shout in case you can't see the slides or if there's any issues, because I'm just having to move stuff around here on my own screen a little bit. So the third request then came in early March from South Africa, where they said, now we're into a situation not just of a risk of famine, as they had been arguing in December, in January, but that famine has actually taken hold. That starvation as a method of genocide was now having uh, lethal consequences for the population in Gaza, and the court had to respond immediately. And in this case, by the end of March, the court did. There was no hearings in that case. They just made their determination based on the written submissions. And by the end of March, the court did order further provisional measures above and beyond what had been ordered in January. So we have two sets of provisional measures orders that are binding on Israel, that Israel is obliged to comply with, that it very clearly hasn't been doing so far. And so again, that raises questions about, the legitimacy of the international system, and um, how well it can possibly work where compliance is voluntary, and that assumes, a good faith intentions on the part of the parties, which clearly we don't have in the case of Israel in this case, or in the case of Russia in the Ukraine case, and so on. So but I suppose what we do have is a set of tools and a set of findings from the International Court of Justice that are very definitive and are very authoritative. The court then set out its timelines, and this is relevant for the question of interventions by third party states, which I'll get to as well. But it's again, we see the slow nature of the process. The timelines were set in April for when South Africa has to file what's called a memorial, so it's full written submission towards the main stage, the main merits stage of the case, which will be where the final arguments and determinations are made, and that will be the longer process over the years to come. And so it's late October for South Africa to submit its memorial, and then it's July of 2025. So more than a year from now, where Israel has until then to file its response, its counter memorial, and only after that then will those next set of proceedings and hearings go from there in mid 2025. In the meantime, obviously things have only gotten worse in Gaza, and we've seen the extent of the consequences of the blocking and denial of humanitarian aid by Israel, and the humanitarian situation worsening. And part of what South Africa is arguing is that apart from the bombardments and the mass killing and execution of Palestinians as an act of physical genocide through murder, there is also a part of the definition of what counts as an act of genocide is the deliberate infliction of conditions of life designed to bring about the destruction of the national group in whole or in part. And so here, what South Africa is saying is that clearly, that kind of indirect indirect physical destruction of the people through the cutting off of water and electricity and fuel, through the blocking of basic medical supplies, through the attacks on the hospital system, the lack of access for the humanitarian aid that's needed, and so on. All of that is part of that Article 2C of the Genocide Convention, and Israel is responsible for violating that. And so, on the basis of what they call the extreme risk that the assault on Rafah this month has posed for humanitarian supplies and basic services to Gaza, and this very survival of what's left of the medical system and the Palestinian population as a group, that this is new facts that are causing irreparable harm to the Palestinians in Gaza. And so they've made a further request and asked for what would be a third set of provisional measures if they were to be granted. And so we had the hearings on that last week, and some of you may have seen the proceedings from the case last Thursday and Friday, I think it was. So that's where we're at now. We're waiting for what the court will respond on that last request from South Africa, and that will be, that could be any day now. The first order came about 2 weeks after the hearings happened, and this one, the hearings were organized even quicker than in January, and so there's an expectation that the order could, if it comes, or some response from the court will come quite soon. So just some of you probably know this and are familiar with it and would have followed it, but there were 6 measures ordered by the court back in January that basically Israel must refrain from committing genocide, must ensure its military doesn't commit genocide, must prevent and punish incitement to genocide. That, and a lot of that is to do with the very explicit calls in public discourse in Israel from everyone from the highest level of government and official leaders to people in the media and public commentators and so on. And some of the rhetoric, as you probably have seen, has been really shocking in how openly genocidal it is, in calling for the total extermination of Palestinians in Gaza and so on. Then the fourth one there was to do with humanitarian assistance and basic services, and that Israel must take immediate and effective measures to allow those services into Gaza. And that's been the one that's kind of been ramped up in the arguments by South Africa since, that Israel's not doing that, and needs the court needs to make an even more explicit and more specific order in respect of that. And part of the argument that was made in January at the time was that even though the court didn't order a ceasefire or a cessation of military hostilities, that essentially by the combination of these other orders, it was effectively saying that is the Israeli military, maybe it could keep some presence in Gaza, but it couldn't continue its operations in anything close to what it had been doing at that time. And that this was a kind of, because the way that the court works, and because there's 15 judges who need to come to some amount of agreement for the court to make its general order, and there always will be the possibility that the judges don't agree, and that some of them will dissent from the main opinion of the court. But the president of the court will always want to have as much buy-in or consensus as possible. And so the sense was, at that point, some of the judges would have been in favor of a full order for Israel to withdraw and stop all military operations, but not enough to have a majority. And so the compromise was to have these other measures in place, and that implicitly, send a message that Israel really had to scale back massively what it was doing in Gaza, even if the court wasn't going to order it to stop altogether. In the March order, then what we had was further kind of language around the humanitarian supplies and so on, and a kind of a reaffirming of the original January order. And here we got closer to and what we know from the separate opinions and the writings of the judges beyond the main order of the court. And from the votes that we can see on the various measures, we know that we got closer to a majority of judges being in favor of a full cessation of hostilities being ordered, but not enough to tip the balance. And so a lot of the discussion now is about whether in this next potential third set of orders, whether that balance will tip over into a majority saying that clearly we've tried to order Israel to scale back its operations and to allow humanitarian access and so on in such a way that it could continue in a limited form to engage in the operations it's been engaged in, but in a way that respects its obligations under the Genocide Convention and stops any potential acts of genocide from taking place. Back in January, people would have said there's no way, the things had already gotten so bad, there's no way that Israel could continue any form of presence in Gaza without further genocidal actions happening, because of those conditions of life having already got so bad. And we know from the reporting from the UN Special Rapporteur on the Right to Food and others that some of the statistics about the levels of starvation and malnutrition and disease in Gaza being the reality that while we've had many other situations of larger scale and bigger populations in other countries being at risk or in situations of famine and starvation or food insecurity, Gaza is in some ways unique in the sense that there's never been a situation since the Second World War where an entire population has gone so hungry so quickly in such a short space of time. And so again, the capacity of an international court that's dealing with quite specific legal definitions to reckon with and to fully and adequately grapple with that reality is a huge challenge, obviously. But South Africa have been trying to push as much on that as they can. This is the kind of extra measures that they've asked for last week, and they're looking for more, basically more specific language from the court to to essentially order Israel to cease its military operations altogether in Gaza, and with the situation in Rafah particularly in mind, to totally and unconditionally withdraw from Gaza, right? And somebody may have watched it or seen it. They're showing video footage that's a frame there from one of the videos that was shown, where we see the Israeli soldiers talking about let's go and destroy Rafah. And you've probably seen a lot of those images that Israeli soldiers have been openly sharing themselves, talking about a Gaza Nakba, or a second Nakba that they're proudly perpetrating in the Gaza Strip. And so what South Africa are talking about is that we need more specific and more explicit orders against Israel, because of the change in circumstances, how extreme the risks are. They're trying to convince the court that the court has the power to do so. The court, a lot of the argument that some of the judges have made against it is to say our mandate is to make sure that the Genocide Convention is respected, but the Genocide Convention, doesn't go as far as saying that a military can't engage in operations in a territory if it feels it has a reason to do so. It can engage in operations, it just can't perpetrate genocide in the course of those operations. And what South Africa is saying is that, in this case, there's no way for the Israeli army to continue its operations without perpetrating genocide. And so the court does have the power to, if it's going to implement the Genocide Convention and ensure it's respected, it does have the power to order a full withdrawal, and that our shared humanity compels the court to do so. And that's the final slide from Lynn Grolig's presentation there, with a testimony from one of the doctors. And some of you have, I'm sure, seen these kind of testimonies and statements about how dire the situation is for the people that are left alive, but in need of medical care and so on. Never mind the people that have been slaughtered. So I'm just conscious of the time. I think I'm nearly up on my 45 minutes or so, and so there's more there in the slides, which, like I said, I'm happy to share. I will just briefly just flick through just to give you a sense. The next kind of part is just about the significance of this. So we have these provisional measures that have been ordered. We know that Israel hasn't complied with them, but they have had this knock-on effect in terms of the duty to prevent genocide and the kind of public sense. And this was Raz Segal writing in the Los Angeles Times after the first ruling, saying that, now that the ICJ has made this determination, every university, company and state around the world will need to consider its engagement with Israel. And that is what we've seen in the last 3 or 4 months. We've seen increasing calls for arms embargoes. We've seen some states starting to review their export licenses and halt the granting of licenses for exports to Israel. We've seen cases going on in the Dutch courts and elsewhere, banning the export of parts to fighter jet parts to Israel, and making specific and explicit reference to the ICJ ruling. So it does have that knock-on effect on other legal systems, where they would defer to the International Court of Justice as the highest court in the UN system. And we've seen that in the Netherlands with the decision against the Dutch government. We know now that the Dutch government has been trying to bypass that ruling by still exporting the fighter jet parts to Israel, but just diverting them through another territory and saying we're selling them to the US or we're selling them to someone else, and then they're being sold on to Israel from there. And so that case, there's more hearings coming back up soon in that case. Even in the US case that was brought against Joe Biden and other US officials for complicity in genocide, which, I think the Palestinian and US organizations and the people involved in taking that case knew it was a very much a long shot, that there is this deference in the American courts to the executive branch of the government on foreign policy questions, and that they were very unlikely to get an order from a court in California to say that that the president or the administration, had to change its foreign policy. But even there, and even while they've said, while the court predictably said we can't make an order against the presidential administration on this, they did still say that, as the ICJ has found, it is plausible that Israel's conduct amounts to genocide. And so the court, even though we've no power to order the president to change his policy, we're imploring the administration to examine the results of their unflagging support of the military siege against the Palestinians in Gaza. And so that's, quite strong language from a US court there. And so we'll see, and that there is an appeal coming up that the lawyers involved in taking that case have brought, and so there'll be another round there, and we've seen with all of the stuff with the encampments and the universities reviewing their relations and policies with Israel, a lot of them referring to the International Court of Justice decision, a lot of the language from different institutions and enterprises that are reviewing their relations with Israel, referring to and deferring to the ICJ and what it has said. Okay, so just the final one I'll mention. I'm happy to talk about this more in the questions, but just in terms of what Ireland's kind of interaction with this case down the line. So there is this provision in the International Court of Justice statute that allows for third parties that are not the two main countries involved in a case, but allows them to intervene, is the language that's used, to make submissions basically in the case, either because they feel that they have a legal interest in the case themselves, that they might be affected by the judgment or the decision in the case, and so they want to make their submission to the court on that basis, or because they feel they have a legal interpretation or contribution to help the judges essentially to better decide the case, that they have a legal argument that will be relevant to how the particular treaty or legal issue in the case is being understood and adjudicated, right? And so we have had already 3 countries, Nicaragua, Colombia, and Libya, who've already filed what are called declarations of intervention to the court, and have said that have made their submissions formally there. And then we've had a number of other states that have made some kind of announcement of an intention to intervene. Germany, most famously, and first of all, when from very early after the case was filed by South Africa, Germany said this is outrageous and this is not a dubious case against Israel, and we'll always stand with Israel, and so we're going to intervene in support of Israel. The whole idea of the interventions is not that you're not meant to be intervening on one side or another. You're meant to be providing a legal interpretation that will help the court to best decide the case. And so, Germany will have to frame its whatever intervention it makes, in that light, in the same way that other countries that have said that they're intervening, whether they've said it explicitly or implicitly, kind of in support of the South African case, they will also have to make a legal contribution to the case. It can't be just we support South Africa, we think they're in the right, and so we want the court to decide in their favor. It has to be presented as a legal submission that is about the interpretation of the law at stake, right? And so that they're the question for so the Irish government, having initially said that, and Leo Varadkar said this explicitly when he was asked about it after South Africa filed the case, that he didn't think genocide was the appropriate language to be using, and that what about Hamas, and maybe that was genocide on October 7th and so on. And so it was a very hostile set of comments and response initially by the Irish government, and Micheál Martin was similarly kind of skeptical of it back in January. But once the order came out, and then with all of the growing kind of social movement and civil society pressure, in Ireland for the government to intervene. Ultimately, they did announce that they would do so in probably around mid-late March. I think that announcement came. Belgium had already said that they would do so. They were the first European country, apart from Germany, the first European country that would be maybe more sympathetic to the South African arguments, who said they were going to intervene. And we've had a number of other global South countries also saying that they will intervene. So, but the question then will be, what contribution are you going to make to the case? The In some ways, this is a relatively new scenario or new trend that follows on from what's happened in the Ukraine-Russia case, where historically it wouldn't have been that common for big numbers of third states to intervene in ongoing cases. There was a decision, basically political decision by the Western countries in the Ukraine case to essentially intervene en masse. It was around 32 or 33 of the Western countries all filed uh, separate individual interventions in that case, trying to make legal arguments in support of the Ukrainian position. But ultimately, that was unsuccessful. There was a decision from the ICJ and in one of the rounds of that recently enough, where they basically rejected the arguments that Ukraine had made on one point they were arguing, and the all of the those interventions in basically in support of Ukraine. And so it is a bit of a reality check, I suppose, in terms of what kind of impact and what significance an intervention can have, and we can't assume that automatically by intervening you're helping or you're doing the right thing. And in many ways, the more interventions there are, the more that will slow down the proceedings and stretch them out, because every intervention that's filed Israel will have the right to respond to, and there'll be a set of arguments and hearings on it. And so there is, I think that the sense is that Ireland will maybe do a joint intervention with some like-minded European states. That's one thing that's being mooted. But again, it's a question of what contribution will that submission, whether it's individual or joint by the Irish government, what value will that be adding? One of the things that has been suggested has been, the particular question of starvation, forced starvation or enforced famine as a particular act of genocide, as a particular technique of genocide, that because of the Irish experience of the famine and the Irish um, the significance in the Irish kind of historical memory of famine as a form of genocidal violence against the population here, that could be, something that Ireland is well placed to intervene on, to build a strong legal interpretation of the Genocide Convention, to say that should be understood and interpreted broadly by the court, right? And so that's one possibility. The fact that only 2 or 3 days ago that the Irish government invited the Israeli ambassador to the national famine commemoration, doesn't exactly inspire you with confidence, let's say. But it will be something that's going to happen if Ireland does go ahead and do this at some point between October, when South Africa files its memorial, and July, when Israel has its deadline to respond. So we're talking about, at some point within the next kind of 6 to 12 months. And obviously, things will also be somewhat contingent on, the political situation, when there's going to be a new election, who the Attorney General is, the submission will be, led by the Department of Foreign Affairs and some of the legal team there. But ultimately it will be, it will go through the Attorney General and the government. And so again, the question of the timeline there and who's in office at that time could also have some impact, right? So that's just to give a little bit of sense of that, but I'm happy to take more questions on that. And I better stop talking at this point, and I'm just going to stop sharing my screen so I can try and see people again. But I will be happy to pass on those slides if people do want to have a copy. So thanks very much.